Do you know why so many EB1A and National Interest Waiver cases get denied? You might think it's due to lack of qualifications or stringent immigration laws, but more often than not, it's the complexity of these cases that becomes the stumbling block. EB1A and National Interest Waiver cases are not your run-of-the-mill immigration procedures. They're a labyrinth of legal requirements where every turn can lead to a dead end, if not navigated expertly. The high denial rates for these cases are a testament to this complexity. Each year, countless hopeful applicants find their dreams dashed, not because they lack merit, but because their cases couldn't withstand the rigors of the immigration process. So, what are the common pitfalls? For starters, it's the lack of compelling evidence. The EB1A category, for instance, requires the applicant to demonstrate an extraordinary ability in their field. But what counts as extraordinary can be subjective, and without robust evidence to back up your claims, your case might not make the cut. Then there's the matter of improper documentation. The immigration authorities are sticklers for paperwork, and a misplaced form or an incorrectly filled out application can spell doom for your case. It's a game of attention to detail, and one small oversight can cost you dearly. Lastly, there's the ever-present risk of misunderstanding the eligibility criteria. Immigration laws are far from straightforward, and the eligibility requirements for EB1A and National Interest Waiver cases are no exception. Misinterpreting these criteria can lead to a flawed application and ultimately a denial. Navigating these challenges can be like walking a tightrope. One misstep and your dreams of immigration can come crashing down, and this is precisely why doing your own case is not recommended. Because sometimes the difference between success and failure isn't about qualifications or merit. It's about understanding the maze that is the immigration process. Consider this case study: an accomplished scientist who decided to file his own EB1A case. This scientist, let's call him Dr. Smith, was a trailblazer in his field, boasting an impressive list of achievements and groundbreaking research. Confident in his qualifications and with an eye on saving on legal fees, he decided to navigate the complex labyrinth of immigration law on his own. Dr. Smith spent countless hours poring over the legal language, preparing his documents, and gathering evidence to showcase his extraordinary abilities. He was meticulous, but the nuances of immigration law are intricate, and without the guidance of a trained professional, he missed some crucial aspects. When it came to presenting his evidence, Dr. Smith focused heavily on his academic achievements and scientific breakthroughs. However, he overlooked the importance of demonstrating how his work was of substantial merit and national importance, a critical requirement for EB1A cases. His case was denied, not because he lacked the qualifications, but because he failed to present his accomplishments in the right light. The consequences of this denial were severe. Dr. Smith found himself in a precarious position, his immigration status hanging in the balance. The denial put his research on hold, causing a significant setback to his career. Additionally, the personal stress and anxiety associated with the uncertainty of his immigration status took a toll on his well-being. This case illustrates the risks and potential pitfalls of self-representation in EB1A and National Interest Waiver cases. It's not just about the depth of your accomplishments, but the ability to present them within the framework of immigration law. Even the most accomplished individuals can falter when faced with the complexities of this process. The stakes are too high to leave room for avoidable errors. Now, imagine if the scientist had partnered with an experienced lawyer, like those at Shah Peer Law Group PC. An expert in immigration law could have guided the scientist through the maze of EB1A and National Interest Waiver procedures, ensuring that every detail was meticulously addressed. This is where the Shah Peer Law Group PC shines. With their in-depth understanding of the immigration law landscape, they could have helped the scientist present a compelling case that stands up to the stringent scrutiny of immigration authorities. They would have known exactly how to highlight the scientist's extraordinary ability and prove that the scientist's work is in the national interest. The team at Shah Peer Law Group PC is not just experienced, but they're also dedicated and committed. They're known for their professionalism, knowledge, and unwavering commitment to helping individuals navigate complex immigration laws. They are the experts who can foresee potential pitfalls and prevent them before they become stumbling blocks. With a 10 out of 10 AVO rating and accolades from superlawyers.com and San Francisco Magazine, they are renowned for their expertise. They have a track record of successful cases, particularly in the EB1 category. They have been featured on international TV networks, a testament to their recognition in the field. By partnering with an experienced law firm like Shapiro-Lee Law Group PC, the scientist could have avoided the mistakes that led to his case denial. Instead of navigating the process alone, he could have had a team of experts guiding him every step of the way. With the right legal help, the outcome could have been very different. So, what can we take away from all this? From our discussion, it's clear that EB1A and National Interest Waiver cases are not a walk in the park. They are complex, intricate, and require a comprehensive understanding of immigration laws. The labyrinth of legal procedures, the meticulous documentation, and the rigorous standards of proof all add up to make these cases challenging even for the most diligent among us. But the trials don't stop there. Opting to represent yourself in these matters can be akin to venturing into uncharted territory without a map. The potential pitfalls are numerous, and the risks often too high. Misinterpretations of law, errors in paperwork, or lack of persuasive evidence can lead to denials, delays, and even potential legal consequences. This is where the value of professional legal help comes into sharp focus. An experienced lawyer, like those at the Shapiro-Lee Law Group PC, can be your guiding light in this intricate legal maze. With their deep understanding of immigration laws, their expertise in handling EB1A and National Interest Waiver cases, and their commitment to their clients, they can help you navigate these challenges with confidence. They can be your advocate, your advisor, and your ally, helping you present a compelling case, avoid common pitfalls, and ultimately strive towards your immigration goals. So let's reiterate the importance of professional legal help. It's not just about having someone do the paperwork for you. It's about having a seasoned professional by your side, someone who understands the system inside out and can guide you through it step by step. Remember, when it comes to EB1A and National Interest Waiver cases, professional legal help isn't just an option, it's a necessity.